When Florida aircraft deals and Florida flight departments end up in court. Hello, yet again. This is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Finally, let's discuss the third hot legal topic in Florida. And this is one that keeps returning to the public in the public record. When aircraft disputes mature into litigation, they usually become fights about paper promises and responsibility rather than about the beauty of the airplane itself. Florida is a natural forum for these cases. The state has a dense concentration of brokers, management companies, FBOs, maintenance providers, charter operators, and aircraft owning entities. When large turbine deals go sideways here, the disputes tend to expose the same recurring fault lines: title, records, inspection rights, insurance placement, agency authority, and post delivery blame shifting. A Broward centered cluster of cases involving Whirljet is instructive because it shows how common these themes are. In UN2JC Air 1 LLC versus Winnington, a Florida appellate court described a Learjet lease purchase arrangement in which the buyer alleged concealed defects, substantial repair expense, and the aircraft being taken from the repair center without notice. The opinion noted that the resulting conflict generated 15 years of litigation. That is not an extraordinary sentence, but it's also a warning. In turbine deals, a bad handoff can create litigation life longer than the useful life of the aircraft. The World Jet Line continued in Zuma Seguros, a Southern District of Florida matter, where the public record reflects allegations involving lack of ownership, access to maintenance and logbooks, and claims that the buyer had been denied the records necessary to evaluate the aircraft. Whether any given allegation was proven is less important here than the pattern. In large turbine aircraft transactions, records access is not a side issue. It is the issue that often determines whether a dispute becomes a lawsuit. The same practical theme appears again in the Don Renee Holding case in Broward, even where the appellate decision addresses injunction and fee questions rather than the entire merits picture. The procedural history itself is useful for an audience. Once a Florida aircraft dispute enters emergency injunction territory, the case is usually no longer about convenience. It's about attempted control over an aircraft, a deal, or a business relationship that has already fractured. And here's something I want you to remember. In Florida turbine litigation, the first argument is often about the aircraft, but the lasting argument is about the documents. This brings us to a more current and dramatic example from the news. In September 2025, Hoppajet Worldwide Jet Charter and related plaintiffs filed a products liability action in the Southern District of Florida against GE. Bombardier, Learjet, Duncan Aviation, and other defendants arising out of the February 2024 Challenger 604 crash near Naples. Public reporting and the docket reflect allegations concerning corrosion, engine-related defects, and maintenance and service provider responsibility. Again, I'm not endorsing allegations. I'm highlighting why the case matters. It shows how quickly a large turbine event in Florida can expand into multi-party litigation involving the operator, OEMs, engine manufacturers, and maintenance organizations. And this is a hot topic because Florida owners often underestimate how litigation broadens after a serious event. The claim is rarely confined to one maintenance act or one failed component. The lawsuit becomes an ecosystem case. Who owned the aircraft? Who controlled maintenance decisions? which records existed, what service information was received, what was deferred, what was disclosed at sale, who had authority to approve the aircraft for return to service. Each of those questions can move liability and coverage. And here's a deeper point. There are no freak events. They arise because Florida is one of the nation's busiest large aircraft transaction and operations markets. The density of activity means the same dispute patterns recur with unusual visibility. So, what should owners, principals, and flight departments do if they want to stay out of this litigation cycle? First, do not close on a large turbine aircraft in Florida with loose assumptions about who owns what. Confirm title chain, FAA filings, lien releases, and beneficial ownership authority with the same discipline a lender would demand. Second, treat maintenance records access as a closing condition, not a courtesy. Full maintenance records, program status, damage history, log continuity, and digital backups should be specified, timed, and verified. Third, align the paper with the operation. If the airplane will be managed, chartered, or made available to affiliate users, the contracts must reflect the actual operating structure. Florida disputes grow when documents tell one story and daily practice tells another. Fourth, plan for the forum before there is a fight. Governing law, venue, escrow instructions, indemnity structure, expert selection provisions, insurance notice obligations, and preservation of electronically stored records all matter more on a large turbine aircraft than many parties admit at closing. And fifth, remember that newsworthiness usually follows concentration. The reason these Florida topics are of interest is not merely that reporters found them. It is that Florida sits at the intersection of money, mobility, seasonality, and density in business aviation. In short, this third hot legal topic in Florida is the reoccurrence of large turbine litigation over access, records, title, and post-event responsibility. The public record from Broward and the Southern District of Florida show that these disputes are not necessarily exotic. They are recurring, expensive, and highly instructive. I'd like you to take this away. In Florida, large turbine cases that reach courts usually begin months earlier when someone accepted ambiguity in place of proof. Thank you for your interest in this topic. This information is provided for informational purposes only and should not be construed as legal advice. Questions are welcome. Please direct them to admin@aviationlegalcounsel.com. We look forward to assisting you with your aviation-related legal needs, and we look forward to answering your questions with precision.